Alex, good to meet you.
Good to meet you too, Kurt.
All right, good afternoon.
Good afternoon, Your Honor.
Good afternoon, Your Honor. How are you?
Very good. First, let me apologize for the late start. I thought I had devoted enough time to my earlier conference, but it ran a little late. So thank you for being patient. There may be a name or two you may not recognize. You probably should recognize Susan Schaefer's name from business court, and Ms. Walker, who's also on the call, works with Ms. Schaefer, and she is just in an observational role.
Fantastic.
Great.
We are live on YouTube. So if y'all would, since this is our first time together, introduce yourselves to me, and who is here for Georgia Greystone?
Your Honor, that'd be me, Kurt Hilbert. Pleasure to meet you.
Hillbrook or Hilbert?
Hilbert, Hilbert.
All right.
And I am Alexander Bell for the defendant, Green Circle.
All right. So it looks like we've already had some motion-like activity. As I understand the posture now, there was a partial motion to dismiss, but based on the acknowledgement of contractual arrangement by defendant, the plaintiff has withdrawn from their complaint counts 2, 3, and 4 without prejudice. So we're going simply on the contractual claim for the time being. Is that correct?
Generally speaking, yes, Your Honor. Contractual claim and the count 5 to the Prompt Pay Act is still viable.
All right.
And then, of course, there are counterclaims that have been asserted as well by the defendants.
Yeah, and we agree with that the counts 2, 3, and 4 are moot. Our motion is moot to that extent. If you'd like us to submit something formally withdrawing the motion, we can. It's up to you, Your Honor.
Yeah, why don't you go ahead and withdraw the motion, and then I don't have to enter an order denying it as moot.
I can do that.
All right, so then let's talk about case management. Have you all had an opportunity to meet and confer?
Yes, Your Honor. We spoke actually this morning and went through the checklist of items for the business court. So we can run through those items with Your Honor real quickly. We've basically agreed to most, if not everything, on the list. And if it's okay with Your Honor, we've set some times and timelines and so on. If you would like us just to go through them, I can take it away.
Yes, go ahead.
Okay. So the length of the discovery period, I think we've agreed that due to the number of truckers and non-parties in the case, we're going to need about 6 months to do that, not the 4-month track. And we'd like that to start from May 25th, today, not from the date the answer was filed. And if any extensions are necessary, it'll be by agreement of counsel or court order if necessary.
So let's extensions only upon order of the court. So I just want to make sure that I get to sign off on it, and it's not automatically granted simply because the two of you all agree. For the most part, I don't interfere with that. If both sides agree, that's fine, but I do need to have sign off on that.
Absolutely, Your Honor. And you know, we're going to diligently pursue discovery here, and we don't anticipate that it will go longer than that. But you never know; there could be another pandemic or whatever that that happens that rocks all of our worlds. So
that's one thing we know, is that we never know.
Yes, exactly. So second of all, the preliminary deposition schedule. Both sides are going to be taking 30B6 combined with their corporate representatives to try to streamline that. So we won't have 4 depositions, we'll have just 2, and we'll combine them together with the corporate representatives. We've got a couple surveyors / other engineers that have done various and sundry things with regard to the lime deposits. And some have produced documentation and surveys, others have not. Some have just been there in person. So we'll have to get to the bottom of all of that and what that all means and how they came to their conclusions. We have some subcontractors that were subcontractors that definitely will have to depose them. One of them is being Frederick Touche, Craig Contracting, who was basically who we contracted, and then he subcontracted to numerous truckers. That just adds a little layer of complexity, but we'll hopefully get through it accordingly. The owner probably will also have to be deposed, and their management company, which is TPA Residential, and then whatever experts either side identify and discovery those as well. But that's what we're looking at in terms of deposition schedules right now of who we're looking at. And if something out of the ordinary comes up, we'll mutually agree to depose those extra folks. So I think we can certainly accommodate and get through all of those in the 6-month period, which should not be a problem. We've already talked about the motions to dismiss. We don't believe there are any other preliminary motions that are known at this point between the parties. We've got an old-fashioned oral agreement here, handshake deal that of course has gone awry. So that's, we have to get into discovery and get to the bottom of whatever's going on here. There will be an on-site inspection at some point, and if we need the court's involvement in that, we'll probably submit something to the court regarding that. I hope that opposing counsel will agree and we can set the terms together as to who, what, where, and what will be done on site, because this is was a tremendous amount of lime deposits that was at this site. And part of the dispute is how deep did it go? How wide is it? How long is it? The volume of it. Obviously, again, the oral agreement doesn't help us much in that regard. So that's something that hopefully will work out. But if we need the court's, help with interference in that, we may need to come to you on that.
All right.
Post-discovery motions, summary judgment, we were thinking that we would be able to file summary judgment motions if necessary within 4 months after the close of discovery. And the reason why we say that is that we are hoping that kind of ties in to our alternative dispute resolution deadlines. We'd like to see if we can't mediate during that 4-month period before the summary judgment motions get filed. But if not, it should be filed within 4 months after the close of discovery. We're obviously open to whatever settlement opportunities we can throughout the case. But definitely we would ask the court to order all the parties to go to mediation. If somehow they voluntarily don't go or counsel recommends it, we'll need your help to make sure everybody shows up.
I'm happy to order mediation.
Yeah, okay. In terms of document production, we have produced approximately 1,800 documents so far. We've date stamped them. We've gone back and forth with a couple of disputes on those documents. We have not propounded our discovery as of yet. That should be forthcoming probably in the next week or so here. So we will know the entire universe of documents here shortly. I don't anticipate that there are going to be many more documents than what we've already produced, other than maybe supplemental from the defendants and perhaps non-party owners. They may have their own surveys. They may have their own documents that we're just not aware of at this point. Let me
stop you for a second. Let me go back. Did you say earlier in talking about dispositive motion 4 months after the close of discovery?
Within that 4-month period. I don't expect it to be that long. If you want it shorter, I'll be more than happy to do that shorter. I just wanted to have enough time for us to get through discovery and actually get to a meaningful mediation process at that point in time.
Sometimes it's helpful to have mediation with summary judgment motion pending. Sometimes that can
be a motivator.
Get people motivated to resolve it before there is an imminent ruling.
Sure.
Let's let's cut down that 4 months to 2 months.
Fair enough.
All right. I think that gives you some time to synthesize and perhaps have some meaningful discussion, but I don't want it to lag too long.
Okay. Well,
Fair enough, Your Honor. That's fine.
Your
In terms of protective orders, we talked about that as well. If there's anything proprietary that needs to be protected, we don't think that the current parties to the case have anything proprietary that would be necessitating a protective order. However, the owner may have some things that they want submitted to a protective order, and counsel and I have already talked that we'll mutually draft something in the event that should arise. But right now, with the current parties, I don't think there's anything that's proprietary or subject to a necessary protective order. You agree with that, Alex?
I definitely agree. That's right.
Now, the next one, the modification of the Civil Practice Act, that kind of stymied me. I don't know what that really means.
I haven't seen I haven't seen an occasion to even consider a modification yet. That there may be some circumstance out there that I haven't heard of to modify it, but no.
Okay.
We're on the same page because we were scratching our heads going, I don't know really what that could be. In terms of facilitating communications with the court, does Your Honor just want us to go through Trinity for things, or do you want courtesy copies as well of filings?
Just go through Trinity. I don't mind if you want to send courtesy copies, send them to Mr. Townsend, and he'll make sure to review them and pass them on to me. Otherwise, my inbox will overflow if I get courtesy copies of everything directly.
Of course.
And I think that covers everything, Your Honor. If there's any other matters that come to your mind that we need to address at this time, I'm all ears.
So, we talked a little bit, we just briefly touched on it with the potential site inspection, but if there's any discovery issues that you come to, and you've had a chance to meet and confer, and it's not resolved, please don't file a motion. Please send an email to Mr. Townsend, and you can it could be as simple as, we have a discovery issue that we're not able to resolve, or it could be as complicated as, here are the contentions of each side that we want everybody to resolve. And we'll get you on for a Zoom hearing like this one real quick and talk through it. I just got off of one of those. That's part of why I was late today, is in another business court case. We had one of those, continuing issues where there's already been a discovery order entered, and one side said the other side didn't fully comply with the discovery order, and we had to talk through it. So let's talk through it, and I think in the most part we can resolve these issues without having to enter a formal order. If we do need one, just so that parties and perhaps third parties have appropriate guidance, then we'll do that. But at the most part, we can talk it through. I can give you guidance, and we can just keep it moving.
Of course.
Fantastic, Your Honor. Thank you. Does the court want us to put together a proposed order on this, or a case management order, or does the court have a form that it prefers, or?
I think Mr. Townsend has a form of order.
Okay.
that he can get to you in form, but it may not cover every one of the topics we discussed, but please feel free to add in what you folks have already agreed to and what we've talked about here. If it's not in the form of the order that Mr. Townsend sends you. He says he sent you the case management order template, so go by that template. If there's anything in there that's been left open that we haven't talked about already, just let Mr. Townsend know, and we can straighten that out. One of the things that we've talked about in some other cases is that sometimes in cases, in these cases or case management orders, we set trial dates, and it's long in advance, and say your trial will be on such and such date, or the pretrial conference will be held on such and such a date. I don't set them at this early a date. We'll, if we get to the point where we have to do that after dispositive motions, then we'll do that. But you know, we're going to get dispositive motions. We're going to rule on them promptly and get you on track for trial if there's going to be a trial. But a lot of times there isn't a trial. We'll resolve it, or the case gets disposed of some other kind of way.
Wonderful.
Great. And if you need a copy of that case management form, Kurt, I've got it and I can send it over to you.
Oh, okay. Or if you want to just go ahead and take the first stab at drafting it, I'm fine with that too.
Sure. I'll take the first draft and send it to you, and then we can send it to the judge for sign off. I think it's supposed to be within 10 days of today. Is that right?
I believe so. Yeah.
All right. Any other business?
Nothing
No.
that I'm aware of, Your Honor. Thank you for your
Look
time.
forward to working with both of you.
All right, very good. Well, we're off on the right foot, so I hope we can continue that way and get this case resolved expeditiously. That's what we're here for.
All right. Well,
Good.
thank you very much, Judge.
All right, everybody have a great holiday weekend.
You too, sir.
Thanks.
Thank you, Your Honor.
Bye.
Bye.